All right, for a larger understanding, let's cut across to our panelists this evening. Joining me, Justice Sanjeev Banerjee, former Chief Justice of Meghalaya High Court, former judge. We have Satyapal Jain, Additional Solicitor General of India, Karuna Nandi, Senior Advocate, Supreme Court of India, Pinky Anand, Senior Advocate, Supreme Court, former ASG, Sanjay Hegde, Senior Advocate, Supreme Court. I'd like to begin with the former Chief Justice of Meghalaya, Sanjeev Banerjee, and I'll cut across later to Satyapal Jain. But Mr. Banerjee, to begin with, what has been the premise in what has happened in the last 3 or 4 days can be mind-boggling for a few. You know, it's often said that there are many Supreme Courts within the Supreme Court where one bench can give a very, very different judgment from the other. And I just want to take you back to 2 judgments which have come. One of Umar Khalid and Sharjeel Imam, where bail was denied. And then you had just a day after that another judgment. Of course, it is one case was UAPA and the other one was PMLA, but where bail is concerned, they have the same provisions. And what is most important, and I just want to stress on, and we can play those graphics out, on what the judgment was. It practically said, sir, that it is well settled that in the state of any prosecuting agency, including the court, has no wherewithal to provide or protect the fundamental rights of an accused to have a speedy trial, then the state or the court or any other prosecuting agency should not oppose the plea for bail on the grounds that the crime committed is serious. Many would think that this is a criticism of the judgment that came a day earlier.
Yes, there are different voices in which some of the judgments speak. And I hope that we have some kind of consistency in both the approach and in the outcome. But that's somewhat unfortunate. But as far as the judgment under the UAPA is concerned, there is a provision in the Act itself. The Act itself is draconian. And once a person is accused under that Act or some charges proposed to be brought against such person, bail is thereafter the exception and jail is the rule. Now, that is the draconian provision. There are several acts which have that and which bind the court. But one of the things that the Supreme Court, no less, should have taken into account is whether our security is so fragile to be upset by, the charges that have been leveled against these persons, and whether, after such a long period of, incarceration, they should have been let out. I think, in my opinion, one should have erred on the side of liberty rather than be cautious on the side of security. And that should have been probably the better approach. But then, when there are different judges, they perceive situations differently. Opinions are different, as would be even between you and me. And therefore, one cannot criticize it as long as they are pegged to certain principles. But the reading of the principles and the enunciation of the principles must be consistent. That is where sometimes, in recent times, we are
because what we've seen, sir, is a fair amount of contradictions. And once again, yes, the judgment, which seemingly, it's not a direct take on the Umar Khalid judgment, but if you read it, it seems to be a criticism of Umar Khalid's judgment, the one which has come in the PMLA case. PMLA and UAP are very, very different. Most would suggest it's comparing apples to oranges. But having said that, the provision of bail under UAPA and PMLA is quite the same. Under UAPA 43D5 of Unlawful Prevention Act, which is UAPA, and Section 45 of the PMLA. And both are very, very similar when it comes to bail. So a ruling in one could have an impact on the other. But Satyapal Jain, I read out the judgment, and it seems to suggest, because one bench completely contradictory to the other bench.
I don't think you can use that word that it is totally contradictory to the judgment of the other bench. The other bench has also not said that delay itself is not a factor for considering bail. In Umar Khalid's case, the Supreme Court found that delay is not the trump card for bail. And secondly, in that case, Supreme Court also recorded that the delay is not only because of the state or prosecuting agency, even the accused are also responsible for that. because they have been taking date after date on one pretext or the other. Having said that, I will say judges take a decision after going through the facts and evidence available on file. As the Honorable Judge just pointed out, there are different acts. The bail provisions in different acts are different. The PMLA section 45 laid down certain conditions for granting bail. UAPA also laid down certain conditions. And these are the laws which have been enacted by Parliament, which has been given the power to enact the laws. They have been upheld by the courts. Therefore, when you apply the principle of bail, you go through the provisions of law, the facts of the case, and the general principle of the right to liberty. Let's not forget, it's not the right of liberty of a common man which is being taken. Nobody is taking the right of a common man. Those people who are accused of certain allegations under a specific act, maybe earlier the IPC, the PMLA, SFIU, and all those things, their bail considerations are based on the provisions of the act, and applying those principles, the courts take a decision. It's not for the first time. If I come to the second point, I'm not saying there is a contradiction, but do sometimes judges differ, and then there is a procedure for that. For example, there is a contradiction on one point, then some larger bench will come and take a decision which out of the two law will be followed. Now, just now you saw that Justice Pardiwala's judgment that the president and governors are bound to decide within 6 months. If they don't decide, they will be deemed to be accepted. They are non-presidential reference. The Constitution bench says no, that is not the position of law. Objectively, they take a decision keeping in view the facts and evidence on file. And if there is a contradiction, if there is any, later on it is sorted out. There is no problem of it.
No, sometimes there are contradictions within the bench as well, but it does seem that there are many versions where it comes down to the interpretation of Article. Fair point.
In Karnataka hijab matter, the two judges of the Supreme Court differed. Justice Hemant Gupta and Justice perhaps...
it's happened, you're right, sir. It's happened on multiple occasions, but what you say that this judgment doesn't criticize the one, nobody's saying it's criticizing the first judgment on Umar Khalid, but when you read it, as a layman, if I'm going to read it, I would think it's an out-and-out criticism, and it does talk about the time frame and incarceration. And I'll bring in Sanjay Hegde into this conversation. Mr. Hegde, if one can just reflect right now to what this particular bench has said, that the state, any prosecuting agency, including the court, and it's said court twice over, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, then the state or the court should not oppose the bail plea on the grounds that the crime committed is serious. To me, as somebody who really, hasn't read too many judgments, will look at this as a complete contradiction and a possible criticism to what I read in the Umar Khalid case, sir.
Well, there is a contradiction, but I don't think it would be a criticism. Quite frankly, what happens is that, especially during the vacations, judges work on their judgments, and one bench does not have the opportunity of seeing another bench's judgment in advance. And it is very rare that judgments are changed overnight. Be that as it may, yes, there is a contradiction. And what really worries me is not the case of Umar Khalid, not the case of the AMCAT promoter. What worries me is the message that goes down to the courts below. What the law laid down by the Supreme Court is binding on all courts, the high courts and the trial courts. So which of these two judgments is the trial court or a high court to pick on? Basically, if they feel like granting bail, they will use the AMCAT judgment. If they feel like declining bail, they may use the Umar Khalid judgment. There has to be consistency, and I do wish sometimes that these issues dehorse the facts of any case, are sort of threshed out in judicial conferences themselves and say that, okay, this is where we draw a line and we will all stick to the line. The law works on settled precedent. If the precedent is settled, we lawyers can tell clients reasonably what can be expected. But in a polyvocal court, if such changes happen, then everybody will be tempted to take a roll at the dice.
All right, so not really by precedence, but maybe by perception. Pinky Anand, to bring you in, the tragedy is not so much that bail is denied, but more so that denials are inconsistent in terms of the judgment?
I'll start with a basic presumption and a statement rather. Bail is not granted universally in any matter, as a matter of course. Bail is a discretionary relief, keeping in mind all the circumstances. So, reading some parts, as people have done, and possibly even you might have done, Article 21 concept, Article 21 stands for itself. But that was not the only criteria to grant or deny bail in either of the cases. So in Umar Khalid, for example, you have UAPA, which is a terrorist activity case, which itself is totally different from the PMLA case, even though ingredients in the two sections for bail may be somewhat similar. That's another matter. But that's one criteria. Secondly, it is a question of security of the state. Third is possible threat if the people are enlarged on bail because there was enough documents or enough other statements to make the fact that they could be tampering with witnesses and the witnesses had yet not started. So there was that problem which is also confronting us. And security of the state, mind you, I don't think has any cudgels with any discussion on that score that you could compromise on that. So these was the factors that were considered in Umar Khalid, aside from the fact that Umar Khalid's case is totally on conspiracy. Even though they have been placed at the helm of affairs as masterminds, this conspiracy element requires a lot to go through as far as establishing the guilt of the accused is concerned. In the PMLA case, you find in the Amtech promoters case, you find that all the documents were supposed to be in the hands of the prosecution. It was documentary evidence. There was no evidence which was to be ultimately, possibly, not no evidence, but broadly it was documentary evidence as far as one understands. So that was a criteria. So how can you compare these apples and oranges? And as I said, bail, since the time we have been practicing, much as we would like consistency within a case, a given case, but not to say that Article 21 means speedy trial and therefore in all cases speedy trial hasn't happened. So you release the accused. That is not the message that has gone down in the Umar Khalid case or any contrary message which has been passed in the other. This is an unfortunate understanding of the judgments. And I say again and stress on the fact that the nature of offences, the serious role of the offences, I mean, PMLA, where that is routing of money. As far as UAPA is concerned, it is security of the nation. And I don't want to elaborate anymore because it's only a question of bail at this point of time. But the prima facie note was found.
Okay, on a larger question, Pinky Anand, I want to bring in Karuna Nandi, but let me ask you this question. Let's not compare these two particular cases, but the sheer fact that the interpretation of Article 21 is very varied across. If you go back to in August 23, Justice Oka's court, a UAPA case, and bail was granted under the same premise that you cannot incarcerate someone even if the nature of crime is very serious. So the same case, UAPA, but interpretation very, very different. You really don't know what you're going to get.
That's what I'm again repeating to you. It has never been done solely on the ground of Article 21. None of the judgments you will find on that score. So you pick up one sentence, one interpretation, it's there. Article 21 does grant speedy trial premise to all accused, no doubt. But that cannot be a criteria to grant a bail on that ground alone. You have to view all these circumstances, the offence, the nature, serious nature of the offence, the possibility of tampering with witnesses, of fleeing from justice, and the regular criteria that are adopted. And the nature of offence is indeed has to be taken. It has been a universal rule in bail cases.
All right, okay. I think Karuna Nandi and even Sanjay Hegde want to come in. Karuna Nandi, you wanted to come in for a rebuttal. Go ahead.
So when the state brought in the UAPA, and it's also true that it wasn't this government that brought it in, it was the UPA government, in fact, that brought it in. However, when they brought it in, what they said was that, look, as long as we invoke national security, as long as we say that you are a terrorist, as long as we set up something that looks possibly like a prima facie case, then we can put you in jail indefinitely, right? However long the trial takes. Now, is there a problem here? And is there a problem for the common man? The problem is this, that since this statute came in, the conviction rate has ranged from about 2% of the cases that they have brought to about 4%. So all the rest of the people then remain in jail until they are acquitted, and a vast majority of these people are acquitted. So therefore, we have a situation where it is a problem for the common person. And the reason it's a problem for the common person is that you have a situation where the rule of law is suspended by Parliament when terrorism is just invoked. And even when the evidence is thin, the courts were shut out. Now, how did our courts fix this? In Union of India versus K. Najib, what the Supreme Court said was they invoked the Shaheen Welfare Association versus the Union of India to say that a gross delay in trial violates the right to life and personal liberty under Article 21, and that it can be used as a ground for granting bail. Now, it is true that the court has adverted to some instances of the accused delaying the trial, Umar Khalid's lawyers delaying the trial, and some instances of the state delaying the trial. But it is still true that the state delayed the trial. So why not just look at that period? Number one. Number two, when we look at the appreciation of the prima facie case, where, despite the fact that in the Salim judgment, for example, the court said that, look, there's no question of just looking at just speech. It has to be a prima facie link to a proscribed organization, and there has to be something that is quite robust. What do you have in Umar Khalid's case? You have no public call to incitement to violence. In fact, quite the contrary, where he keeps calling for peace. Number two, there's no material on record showing Khalid's participation in funding or transporting arms, and there are no recoveries from him. Number three, when the riots took place, the man was not even in Delhi. And these are all admitted facts, right? So I think that what troubles me, and it's true in a polyvocal court, there will be some disagreements, on particular facts of cases between. But
all right,
however,
Sanjay Hegde also, I'll just come back. Sanjay Hegde also wanted to come in, and I'm going to take one more intervention from everybody. Sanjay Hegde, you wanted to come in for a rebuttal. Go ahead.
No, I was responding to
Pinky Anand, yes. Ms. Pinky Anand, yes.
Pinky said that, UAPA stands on a different footing. But in the same UAPA case, you have granted bail to about 5 people. Now, it's not the UAPA which is the problem. It is the perception that some people are more dangerous, and therefore, and no matter that, we can't conduct a trial. We can't conduct a trial for anyone. We might as well keep these people in for longer.
That's not the argument, Sanjay.
Okay.
I would say that is hardly the stand that has been taken. It's just that the role of these accused is more serious.
Exactly.
They're at the helm of affairs, and that is the reason why bail was denied. And that happens in every case. It's not UAPA alone. In all cases, you do have differentiation between different roles of accused.
So that's the question. Ms. Anand, then let me come down to that question, and I'll ask you that question again, because let me quote a judgment. August 13, 2024, Justice Oka and George Massey's court, a case which was UAPA, and the judgment said the bench granting bail noted that bail is, of course, rule. Jail is not an exception. Even in cases like UAPA, you cannot indefinitely incarcerate if the trial is not over. So my question, Ms. Anand, is that this is a UAPA case, and this was one bench which was hearing it, and then you have a bench which was hearing Umar Khalid's case, which is a UAPA case as well. Yet you have very, very different judgments.
I told you earlier that the roles of accused varies in every case, and that is why the differentiation may happen.
So it's perception.
Yes, it's not perception. It is what you judge. It's what you see from what is available before you. The criteria whether a prima facie case is made out, the seriousness of the role of the accused, and it varies in every case, whether it's murder, whether it is suicide, whether it is abetment to suicide, any of those cases. So you can never say that in a given case you cannot differentiate between different accused or in a different case. It will come up on its own. So that would be a very unfair statement to make. In bail is the rule. That's correct. But in these cases, as Justice Mukherjee said, bail is not the rule.
Okay, fair point, because, for the layman, it actually comes out as it's not rule of law, but it's rule of bench. One bench hearing exactly the same case will give bail, and the other one wouldn't. Satyapal Malik wanted to come in. Go ahead, sir. Satyapal Jain wanted to come in. Go ahead, sir.
I'll take your leave now.
I have to make 3 small
Okay, ma'am. Thank you for joining us. Thank you. Yeah.
Okay.
3 small submissions. Number 1, so far as the bail matter is concerned, bail is not a matter of right. It is the discretion by the court, which is exercised by the court, keeping in view the facts, law, and all that. Number 1. Number two, there is a basic flaw with the criminal law. With respect, I am saying that if there is a doubt whether you have committed a crime or not, you will be booked. There will be trial, evidence, and all that. And ultimately, at the fag end, if there is still a doubt whether you have committed the offense or not, you will be acquitted. So this is a, to my mind as a lawyer, the doubt creates problem for you. Ultimately, doubt saves you. Number three, so far as this application of the principles regarding bail are concerned, ultimately the judges who are deciding that case, the power has been vested by the constitution in them. They apply their mind, they decide the cases. And wherever there is a necessary, they give the right also. In Umar Khalil's case, I'm sorry, extremely sorry. In that case, Supreme Court says the delay is there, and if within 1 year the prosecution doesn't proceed with the trial, they will have the option to come again for bail. So their bail has not been permanently denied. They say because the allegations are serious, therefore we give 1 year more to the trial court. If they don't proceed with the trial, you come and apply for bail. So all
right.
these
Okay, fair point.
the
You know,
point,
the conversation is
point
not so
I'm
much. We've
making,
already debated Umar Khalid's case, but I want to take final submissions. Justice Hegde, you wanted to come. Mr. Hegde, you wanted to come in, and then I'll go to Justice Banerjee.
Jan Malik and Justice Sanjay Hegde.
Essence of
Go ahead.
The
no,
problems
exactly.
are
Freudian slip, sir. Go ahead.
Okay.
May
The
I?
sense of tyranny, Justice Banerjee, give me a minute. The sense of tyranny is the ability to make a harsh law and use it selectively. If the courts then approve of such selectiveness, if the prosecution is able to, say that we can't have a trial, it is going to take a long time. But in the meanwhile, believe our fairy tales in the charge sheet against only these people, these are the real culprits, then I do think it is the court's constitutional duty to say, look, if we can't conduct a trial, if this is the nature of the evidence, we are going to give bail to everyone.
Okay, Justice Sanjeev Banerjee.
Yes, I think the problem is that we do not have the resources really in the judiciary to conclude matters within any reasonable time. The judge population ratio is very bad, and this issue has to be addressed. Increasingly, we are seeing that we punish the poor and the rich get away. There is a terrible problem of judge-lawyer nexus in the judiciary, and it begins right from the top. And more, we find that courts are aligning with the government of the day in certain matters. These are disturbing trends, and I hope that I'm wrong in my perception regarding these. Bail is really the rule, and liberty is something which is paramount and ought to be safeguarded. And the Constitution and the Supreme Court, should stand up. The Constitution does. The Supreme Court should stand up for liberty. And I am slightly disappointed in why the two did not get bail. I probably would have looked at the matter in a different angle.
Fair point. That exactly. So, that's what I said. There are many Supreme Courts within the Supreme Court as well. Satyapal Jain, final words, sir.
I totally agree with the Honorable Judge, the
I'll come
Honorable
to you,
former
Ms.
Judge,
Nandi.
that now, unfortunately, the law is tilting towards the rich. The rich are able to get away with the intricacies of the law. They can engage very, very senior lawyers. A common man, maybe a peon, maybe a shopkeeper, maybe a farmer. They keep on standing in the queue for years together. And the big people, you see the list of people against whom PMLA is there. The UAPA Act is there. They're all very influential big people. There is never a case of PMLA against a peon, against a clerk, against a shopkeeper, against a common man. And these very rich people, I am saying it, full sense of responsibility. Unfortunately, my personal impression is law and system is inching and tilting towards the rich. That is the most unfortunate part of the system.
Ms. Nandi, final points, ma'am.
The Twaha Faisal case was in some ways quite similar to the Umar Khalid case. And the reason I'm bringing up this specific case is because it said that mere association or ideological inclination does not meet the threshold of Section 43D, and that there has to be a further, an act furthering terrorist activities. Now, there are a number of cases like this. The difficulty when we have cases that don't rigorously follow precedent, particularly when they are upholding liberty, is that you then have a situation that huge numbers of people will be affected when their cases go to the sessions judges and it goes up the chain. And I think that is the essential problem with the doctrine of positive precedent with regard to 43D.
All right. I appreciate all of you for joining us. Thank you for taking the time out and being with us this evening.